Hot.
It's 5:05 and welcome into a Monday edition of the Carolina Journal News Hour. News Talk 1110 99.3 WBT. I'm Nick Craig. Good morning to you. We start off this morning with breaking news in the high-stakes race for the North Carolina Supreme Court. To get an update on that, Mitch Kokai from the John Locke Foundation joins us this morning. Mitch, there was a court hearing on Friday, and it wasn't long after that in Wake County that we know some additional details about the race between Allison Riggs and Jefferson Griffin. What are you learning this morning?
Well, this is really the outcome that we had been looking for a month and a half or more in this, and that is the first court hearing deciding whether the State Board of Elections was right or wrong in throwing out election protests from Republican State Supreme Court candidate Jefferson Griffin affecting 65,000 or more ballots. You'll remember that in December, the Board of Elections rejected these ballot challenges, and Griffin went to court. He first filed a petition with the state Supreme Court, and then the day after that happened, the State Board of Elections moved the case from state court to federal court. It sat in federal court for a while. Then U.S. Chief District Judge Richard Myers sent the case back to the state Supreme Court. The state Supreme Court issued a temporary stay, and then a couple of weeks later sent the case back to a trial judge in Wake County Superior Court. But at the same time, the State Board of Elections and Democrat Allison Riggs tried to get the federal courts to take the case back. The Fourth U.S. Circuit Court of Appeals said, no, we're not going to force the U.S. trial district court judge to take the case back. And so the case remained in Superior Court, and we finally had the hearing dealing with Griffin's challenges. And so the hearing was held on Friday morning, and not too long afterward, Judge William Pittman issued a one-page order rejecting Griffin's ballot challenges. And basically, I can read you the crux of the argument, which was the court concludes as a matter of law that the board's decision, meaning the Board of Elections, was not in violation of constitutional provisions, was not in excess of statutory authority or jurisdiction of the agency, was made upon lawful procedure, and was not affected by other error of law. Oftentimes, court decisions are lengthier, but William Pittman, the judge in this case, confined it to a single sentence, saying that there aren't any constitutional violations. The State Board of Elections didn't break any law. They followed the proper procedure, and they didn't commit any other error of law. So that's a fairly distinct and concise opinion in this case. That doesn't mean the case is over. Jefferson Griffin is expected to appeal. Whether he'll appeal directly to the Court of Appeals, which would be the normal course of business, or if he'll try to kick it back up to the state Supreme Court quickly, remains to be seen. But at this point, the news is good for Allison Riggs, and it would only change if either the State Court of Appeals or the State Supreme Court decides to reverse Pittman and rule in Griffin's favor.
Now, Mitch, we heard from the judge that he did not want to rule from the bench on Friday, and in fact, he didn't rule from the bench on Friday. However, he did have his ruling out pretty quickly within about 5 hours of that court hearing. Is that typical in a case like this, or because it's been going on for so long and most of the arguments were already known, does that kind of lend itself to this quick ruling out of the Wake County Superior Court?
I would say that it's not typical, but as we know, this hasn't been a typical case. And when the case came back from state Supreme Court to the Wake County trial court, the Supreme Court asked the trial judge to act expeditiously. Remember, this was an election that took place, as we all know, in November. We're now 3 months past the election, and this is the only North Carolina election and one of the few, if not the only elections across the country that's still not settled. The other thing that's coming up is that the state Supreme Court returns to work on Tuesday, starting to hear new cases, and this still is unresolved. Now, Allison Riggs, because she was an appointed incumbent and already had the position, will continue to serve on the state Supreme Court as this case is playing out. But there is a sense that this needs to be resolved at some point. So in a normal case, you would either have a ruling from the bench, or the judge or a panel of judges would take the case under advisement and then issue a ruling. If they need to write something substantial, it might take a few days, a week, might even take a couple of weeks or longer to get that ruling written. At this time, I think because the Supreme Court asked the Wake County Superior Court to act expeditiously, Judge Pittman heard what he heard, kind of came to the conclusion that I side with the Board of Elections and Justice Riggs against Judge Griffin in this case. I might as well just spell it out as quickly as possible so that the rest of the court action can proceed and people aren't just waiting on me to come up with a ruling.
Now, Mitch, you've talked to us in the past and walked us through this temporary stay that was put in place by the state's highest court, the North Carolina Supreme Court. Is that still in effect as of this morning, or could the State Board of Elections convene and certify this race?
The stay remains in effect. In fact, that was one of the points of complaint from Justice Anita Earls, who's the other Democrat on the state Supreme Court. She basically argued that by putting a temporary stay in place throughout the course of the legal proceedings, that the state Supreme Court was already putting its thumb on the scale. She thought this is something that should have been left to the trial court. But the state Supreme Court said in some of the rulings, especially I'm thinking of Chief Justice Newby's concurring opinion, that in election challenges, it's not atypical to have a stay in place until everything is resolved and the final appeal is finished. And so that temporary stay does remain in effect. The Board of Elections can't sneak in, call a meeting and certify Justice Riggs as the winner. Because remember, once certification happens, basically the rest of the lawsuit, the rest of the challenge becomes moot. That's one of the reasons why Jefferson Griffin acted in the way that he did. He wanted to get a stay in place, if not an injunction, so that the election couldn't be certified until all of his various ballot challenges had been heard. So the case will proceed through the appellate courts with that stay in place, and the Board of Elections cannot take action until all of the legal issues are resolved.
You just mentioned the appellate courts right there and mentioned that this is likely not the final step for this case. So what are we expecting probably to come down in the next couple of days?
Well, as we're speaking, I've not yet seen documents from an appeal, but what will be very interesting to see is, does Jefferson Griffin go to the Court of Appeals, which would be the normal step when you're appealing an action from Superior Court, or does he try to bypass the Court of Appeals and go back to the state Supreme Court? We know that he took the unusual step in mid-December of bypassing the Superior Court and the Court of Appeals and going straight to the Supreme Court, trying to get something called a writ of prohibition to block the Board of Elections from acting in this election. Now, the state Supreme Court rejected the writ of prohibition, but it did put in place that temporary stay, which gave Griffin the chance to play out the rest of this legal proceeding. So we will either see a court filing in the Court of Appeals or a filing that tries to bypass the Court of Appeals and go back to the state Supreme Court. Or we could see both. He could file his appeal in the Court of Appeals and then also file something with the state Supreme Court saying, in the interest of resolving this as quickly as possible, you should bypass the Court of Appeals and take this case up yourself. It probably depends on whether he thinks he would get a ruling in his favor from the Court of Appeals. If he's unsure of that, knowing that at least some of the justices on the state Supreme Court have shown some interest in his arguments, he might say, okay, it would be better for my case to go straight to the state Supreme Court. And remember that because of some of the other rulings that have taken place, including a ruling from the Fourth U.S. Circuit Court of Appeals, the State Board of Elections and Justice Allison Riggs have already signaled that if they lose in the state courts, they're going to take this case back to the federal courts and try to get a ruling in their favor there.
Lots of moving parts here. We'll continue to track it over at CarolinaJournal.com. Mitch Kokai from the John Locke Foundation joins us this morning on the Carolina Journal News Hour. It's now 5:14, News Talk 1110, 99.3 WBT. We will get a look at traffic on this early Monday morning, an update with Boomer Von Cannon.
Thank you, Nick.
It's 521. Welcome back to the Carolina Journal News Hour. News Talk 1110 99.3 WBT. As millions across the United States watched the game last night, North Carolinians got their first chance to wager on the game legally. This is the first year that betting on the big game was legal in North Carolina after state lawmakers passed a sports betting bill in March of last year. This is pretty remarkable. Between March 11th, when the law went into effect, and December the 31st of last year, it generated more than $1 billion in the state of North Carolina. According to North Carolina state law, residents could only bet on actions that happened during the game. So you couldn't gamble and can't continue to gamble on things like how long the national anthem will be. So while residents can't legally wager prop bets, the big game is still expected to generate massive revenue for the state as we get closer to 1 year since sports wagering became legal. And while North Carolinians may look to gamble, well, some are wondering how their winnings in 2024 will affect their taxes, as the IRS began accepting tax returns just a couple of weeks ago. According to NC State's College of Management, your winning bets are subject to income tax, and the cost of lost bets is an itemized deduction, meaning taxpayers who take the standard deduction, which is $14,600 a year if you're filing as a single taxpayer, or $29,200 if you're married on your 2024 returns. However, in North Carolina, you will pay taxes on any winnings, but you cannot deduct the cost of losing bets, even if you have a net loss. And we've talked about some legislation over the last couple of weeks that has been introduced in the General Assembly to change that. That has not gone into effect yet. We'll continue to track the details right here on the Carolina Journal News Hour. At a meeting on Friday, the North Carolina State Health Plan Board of Trustees discussed potential solutions to address the plan's projected deficit, which is pretty significant. $507 million in 2026 and between $800 and $900 million in 2027. Major deficits for the state health plan, with one proposal coming forward, including raising the monthly premiums for state employees by an average of 30%. However, not everyone at the meeting loved that idea. The board discussed how the plan reached the financial situation and it is in right now and explored various strategies to close the funding gap faced by the state health plan. It was emphasized that a vote on a premium increase would not take place until much later this year, sometime around August, and employee premiums and benefits, important to note, have not been adjusted for 7 years. This is despite rising healthcare costs across the nation. SHP officials explained how the plan reached the point of impending shortfall. Contributions from the North Carolina General Assembly, our state legislature, average about 3.3% of that. Medical costs and pharmacy costs have gone up significantly over the last few years, and funding from reserves have been used to plug a gap instead of increasing an employee contribution or change in plan design. Problems pointed out with the clear pricing model, which were increased reimbursement rates for specific services, for example, primary care, behavioral health therapy, combined with the reduced copays, led to significant plan costs. Another issue, the cost was originally estimated to be about $100 million for the initial 2 years with no ongoing costs. However, the actual costs were significantly increased above where that was expected. Officials noted that while reviewing the clear pricing project and emphasizing price transparency and unit costs, not enough attention had been given to improving plan members' health. They want to refocus on that aspect, as better health outcomes could have helped reduce costs. It was concluded by the board that if a 2% annual premium increase had been implemented in 2017, it could have prevented the projected 2026 budget shortfall. Aligning premium adjustments with state employee salary growth, they say, could have resulted in an average of $165 million in reserves above the required minimum cash balance, softening as well as softening future premium increases that we're talking about this morning. An average increase of $30 per month in premiums according to officials, would generate around $100 million. However, they did stress that they would like to keep premium increases at $20 per month for the lowest paid employees and as much as $50 per month for those making over $100,000 a year. An unidentified woman who spoke during the public comment period asked why state health plan officials couldn't negotiate new pricing with their vendors instead of asking employees to foot the bill. She said that that right now members are hurting and rising prices for everyone else and for a rise in premiums cannot be justified. The unidentified woman said during the meeting, quote, "North Carolina is the number one in the country for the cost of health care. We all know that means that we're number one in the world because our nation is the costliest place for healthcare in the world. You have a responsibility not just to state employees, but to every taxpayer in this state and in the nation that we are the worst around." Not very positive comments there. The president of the North Carolina Association of Educators and the State Public School Employees Union, Tamika Walker Kelly, also said she was opposed to the increases. She told the board, quote, "I know that if teachers and school employees are asked to pay more for health care and taking more out of their already meager compensation, then we will lose more teachers and more staff in our classroom. The percentage of how much they pay cannot be independent of this flat salary that our educators have been experiencing for more than a decade. We won't be able to reach more students." Walker Kelly said that it would exacerbate what she called a crisis in the state public school system. She went on to say, "Our crisis was created by state lawmakers who have failed to provide salaries that meet rising costs that we are dealing with. And therefore, I say to state lawmakers who should pay to close the healthcare gap, not our school employees. And it's not just about saving teachers money, but it's really about the students who come into our school buildings every day. Today, I would like to give you an invitation. We call on all of you who are present here today to join us in advocating for increased pay rather than making it harder and more challenging for educators to access quality health care for themselves and their family." It's important to note that the General Assembly has passed and continues to increase teacher pay across the state. They did that in a couple of budgets that were, in fact, vetoed by Democrat Governor Roy Cooper. However, that did not stop Tamika Walker Kelly from talking about that during the meeting on Friday. The state health plan board will meet again next month for a more in-depth discussion on possible increases. So that is something that we will be tracking as rising healthcare costs are seemingly affecting everyone across the nation. And it looks like, at least in the semi-near future, we could be talking about that in regards to state employees that are part of the North Carolina State Health Plan. We'll continue to track those details over at carolinajournal.com, where it's now 5:29, News Talk 1110, 99.3 WBT. It's time to get another look at traffic on this Tuesday morning, an update with, Monday morning rather, an update with Boomer Von Cannon.
You got it, niggas.
It's 5:36. Welcome back to the Carolina Journal News Hour. News Talk 1110 99.3 WBT. We are streaming live this morning, as we are each and every morning, on our Carolina Journal YouTube channel, where you can watch along live. Also encourage you to check out the podcast. You'll find it wherever you get your shows. Just search for the Carolina Journal News Hour, tap the subscribe or follow button, and you'll get a new show delivered to your smartphone or tablet each and every weekday morning. It's the Carolina Journal News Hour podcast. Download and subscribe now. Turning our attention to Washington, D.C. this morning with an impact on North Carolina. On the day of his swearing in, newly inaugurated President Donald Trump issued an executive order that effectively halted the Biden administration's push to rapidly develop offshore wind development facilities across the East Coast. The order withdrew the Outer Continental Shelf, or OCS, from offshore wind leasing and reviews the federal government's leasing and permitting process for these projects going forward. The order reads in part, quote, "This withdrawal temporarily prevents consideration of any area in the OCS for any new or renewed wind energy lease for the purpose of the generation of electricity or any other such use derived from the use of wind." It goes on to say this withdrawal does not apply to leasing relative to any other purposes, such as, but not limited to, oil, gas, minerals, and environmental conservation. Nothing in this withdrawal affects rights under existing leases in the withdrawn areas. Now, experts have indicated that the issuance of this order will impact the energy industry and could lead to a decline in whale deaths off the East Coast, which was a major topic of discussion over the last couple of years. The John Locke Foundation Center for Food, Power, and Life has highlighted numerous concerns about large-scale wind projects off the North Carolina coast. They include higher electrical costs, job losses, negative impacts on coastal fishing and tourism, some issues with military training and radar interference, and the heightened risk of building in the state's hurricane-prone waters. John Sanders, who is the executive director of the Center for Food, Power, and Life over at the Locke Foundation, said, quote, "Another reason is the deadly effect that construction and operation of offshore wind energy facilitates have on marine birds and animals, especially the critically endangered North Atlantic right whale. Already nearing extinction, these whales have been furthermore classified by NOAA Fisheries under the unusual mortality event since 2017. The rapid declining population is down to an estimated just 360 whales left, only of which 70 are capable of bearing calves or offspring." The Biden administration had swiftly pushed forward a plan for 32 offshore wind leases along the East Coast during his administration, placing them directly in key areas where they feed and calving areas for the whales. Meanwhile, officials downplayed the potential risk to these marine mammals. In 2022, the Bureau of Ocean Energy Management and the National Oceanic and Atmospheric Association, NOAA, stated that the right whale population could not sustain even a single death or serious injury from human cause in a year. By 2023, NOAA Fisheries estimated that the Coastal Virginia offshore wind project could result in the death or serious injury of 8 of those whales annually. Yet in 2024, that tune changed as the National Marine Fisheries Service revised its estimate, claiming that the project would not harm a single whale. That was despite an ongoing federal lawsuit challenging this conclusion. However, NOAA insisted that, quote, "No evidence existed that the offshore wind development kills whales." The Biden administration pointed to key elements to blame for whale deaths near offshore wind projects: vessel strikes, which of course were associated with the wind project, fishing gear entanglement, and climate change, driving the whales into areas where they are likely to be struck by boats or become entangled by fishing gear. The administration did not acknowledge the impact of extensive wind facilities being built, which include sonar activity, excessive loud pile driving, noisy operations, and other activities that take place in the whales' feeding and calving paths. disrupting them and driving them into paths of boats, fishing gear, according to Sanders. In March of 2023, 3 dead whales in 3 days, 2 humpbacks and 1 manakie washed ashore near the Virginia project and the developing Kitty Hawk wind energy area. During the span of 1 week in December of 2023, a North Atlantic right whale was seen and believed to have died due to being entangled in fishing gear in the Outer Banks. In the same week, a dead humpback whale washed up on Kitty Hawk Beach, and overall 11 whale deaths were recorded in 2024 off the coast of North Carolina and Virginia. According to the John Locke report from earlier this year, it says, quote, in this blame shifting, a catalyst for exacerbating whale mortality events gets recast as the solution. Of course, it relies on people buying into the notion that 32 offshore wind facilities would actually mitigate carbon dioxide emission, even though to mitigate climate change, with among many other things, would require ignoring that the United States has been leading the world in reducing CO2 emissions from energy, while China has been much outpacing and increasing emissions many times over the amount that the U.S. has cut. Intermediate energy solutions impose significant costs on ratepayer, according to John Sanders. Research published last year revealed that relying on intermediate sources of energy like wind and solar to meet carbon plans' generation needs rather than dependable, efficient sorts of energy like nuclear power would require constructing 8 times more capability and 9 times more transmission infrastructure. Additionally, the report estimates that it would consume vast land covering nearly 1/5 of the state's onshore acreage. The report authors say that these costs would ultimately fall on the North Carolina electrical consumer. Sanders concluded by saying, unlike the Biden administration's heedless and hurried approach, the Trump order puts a halt to all new or renewed approvals, right-of-ways, permits, leases, or loans for offshore or onshore wind projects pending the completion of a comprehensive assessment and review of the federal wind leasing and permitting practices. Sanders says, importantly, this assessment must include the project's environmental impacts on wildlife, including birds and marine mammals, and it must also take into account the economic costs associated with the intermediate generation of electricity, as well as the effects of subsidies on the viability of the wind industry. So that is one of the many executive orders that you've heard about over the last 21 days or so. You can read more details, including a link to that full John Locke Foundation report on energy over on our website this morning, carolinajournal.com, where it's now 5:44, News Talk 1110, 99.3 WBT. We will get another look at traffic this morning, an update with Boomer Von Cannon.
Hey, thank you, Nick.
Good morning again. It's 5:50. Welcome back to the Carolina Journal News Hour. News Talk 1110 99.3 WBT. Recapping our big breaking news this morning from Friday. A Wake County Superior Court judge has rejected North Carolina Supreme Court candidate Jefferson Griffin's attempt to discard or throw out over 65,000 ballots in his election against Democrat Allison Riggs. Judge William Pittman upheld the State Board of Elections' decision to reject Griffin's ballot challenges, ruling that the board acted within its legal authority. Griffin, who currently trails Riggs by 734 votes, is expected to appeal. We don't know exactly when that will happen. It could happen as early as today. The case could ultimately return to the state's highest courts, where a Republican majority previously granted a temporary stay, preventing the State Board of Election from certifying Riggs a victory. A federal court also declined to hear the case, but left open the possibility of revisiting any sort of federal legal issues after state rulings. Griffin's ballot challenge includes 60,000 voters lacking certain registration details, 5,500 overseas voters without photo ID, and 267 individuals who have never resided in North Carolina. A win for Riggs would maintain the court's 5-2 Republican majority, while a Griffin victory would expand it to 6-1. However, until the dispute is resolved, both candidates will remain in their current judicial roles. Griffin currently on the appellate court, Riggs currently serving on the state's highest court. We'll continue to track those details, likely some movement throughout the week. We'll pass it along to you right here as soon as we learn more on the Carolina Journal News Hour. Turning our attention to the General Assembly this morning, a bill introduced last week in the North Carolina Senate aims to empower local school districts to reduce the use of smartphones and similar devices during instructional time in public schools. This, of course, has been an issue for many years. Senate Bill 55, sponsored by Republican Senators Michael Lee of New Hanover County, Jim Bergen of Harnett County, and Lisa Barnes of Nash County, encourages school boards and charter schools to develop and enforce policies that limit distracting technologies in the classroom. The bill requires at a minimum schools should prohibit students from using, displaying, or having powered-on wireless communication devices during instructional time. This includes, according to the bill, cell phones, laptops, tablets, pagers, two-way radios, and gaming devices. Schools will have the flexibility to decide specific violations and implement consequences, such as confiscating the devices or instituting disciplinary actions. Senate Bill 55 provides several examples where it says teachers could authorize the use of devices for educational purposes, and exemptions may also apply for medical reasons or special education plans. Under the measure, schools would need to define consequences for infractions, which may include confiscation of the device or other sort of actions. According to Dr. Bob Lubke, who is the director of the Center for Effective Education at the John Locke Foundation, he says, quote, "It's time local school boards take the lead in eliminating distracting technology from the classroom. The inability to properly limit technology has a dire academic and social consequence for our school children. Every school board should think through such a policy and adopt it for their schools. Parents and students will thank them for doing so." The proposed legislation comes amidst growing concerns about the impact of phone use on student learning and well-being, as research has pointed to these devices as a major classroom distraction and a possible driver of a social media addiction. At least 19 states have enacted similar statewide measures or guidelines, while others recommend local school districts create their own policy. As of mid-2024, at least 19 states in the U.S. have implemented those laws or policies to ban or restrict cell phone use in the classroom, with some requiring local districts to enforce their own rules, with other states considering similar measures in this legislative session. North Carolina, one of those. We'll keep an eye on Senate Bill 55 and let you know as soon as it moves on out of the Senate and any additional details right here on the Carolina Journal News Hour. Some potential concern for members of the North Carolina State Health Plan as the Board of Trustees met on Friday to discuss potential solutions to address the plan's projected deficit. And it's a remarkable deficit, $507 million in 2026 and between $800 and $900 million in 2027. That is causing one proposal to come forward, which would potentially raise monthly premiums for state employees by an average of $30. However, not everyone that was at the meeting on Friday and a member of the Board of Trustees is in support of that idea. The board discussed how the plan reached the financial situation that they were in and explored various strategies to close the funding gap from the state health plan, and it was emphasized that a vote on premiums would not take place until sometime in August. Now, health rates have rose across the country, and employee premiums and benefits have not been adjusted for members of the state health plan in 7 years, despite those rising health care costs. Those officials from the state health plan explained that the plan reached the point of an impending shortfall because of those factors. Contributions from the North Carolina General Assembly average about 3.3% per year, and medical costs and pharmacy costs have gone up significantly, and funding them from reserves has been what the health plan is used instead of an increase in employee contributions or change in the overall plan design. So again, as I mentioned, nothing will be happening until sometime later this year in August. However, the idea that was floated around, an average increase of $30 per month in premium. However, they did stress that they would like to keep the increase to $20 per month for the lowest paid employees in the state, as to as much as $50 a month for those making over $100,000 a year on the state health plan. And they estimate that that could generate about $100 million a year in additional revenue for the state health plan. So this is something very dynamic. We'll keep an eye on it over at carolinajournal.com. That's going to do it for a Monday edition of the Carolina Journal News Hour. WBT News is next, followed by Good Morning BT. We're back tomorrow morning, 5 to 6, right here on News Talk 1110 and 99.3 WBT.